Hello, everyone, and welcome to today's webinar on protecting innovation, IP law for tech founders. I'm Ijoma SK, and I'll be the moderator for this session. And with me is Barista Noma, a seasoned corporate and tech lawyer, and our speaker for today, who'll be walking us through the practical side of IP protection, what it means, why it matters, and how to apply it right from your earliest product stage. And today's webinar is part of our H2 2025 series, a 5 month legal deep dive designed to help startups build smarter, safer businesses by tackling legal gaps. So, from August to December, we've been rolling out a rich blend of live webinars, practical freebies, expert led posts, legal services, and strategic resources, all curated to guide founders through the legal foundations they can't afford to get wrong. And just in case you've missed any of these webinars, you could easily click on our channel and go to replay it. So, over the next 40 minutes, we'll be breaking down key areas that every founder should understand, from the difference between copyrights, trademarks, patents, and how each applies to your startup, to software licensing, how to control who uses your code, under what terms, and finally the IP clauses you must include in every contract with co-founders, employees, and investors. This isn't just a theoretical conversation, it's a practical one. And by the end of this session, you'll know exactly how to secure your data, protect your brand, and avoid the kind of ownership mistakes that derail even the smartest startups. So, whether you're just sketching your product or idea, or you're already scaling, this webinar will give you the clarity and tools to own your innovation legally and confidently. Once again, welcome to today's session on IP protection. For today, I would like to give a brief intro and bring it closer. So, basically, innovation in the tech ecosystem is advancing rapidly. AI, fintech, health tech solutions, blockchain applications, and automation tools are reshaping the industry at an unprecedented pace. However, this same speed of innovation has also increased the risk of idea theft, code copying, and unfair competition. Once a product goes live or a prototype is shared, it becomes vulnerable to imitation if it's not legally protected. Just like a notable example is the 2018 dispute between and Waymo and Uber, where Anthony
Give us a minute, guys. I guess Ijoma is having network issues or something. Okay, I guess I'll have to take over for Ijoma while she figures it out with her network and all that. Hi, guys. I'm Norma Grace, and as Ijoma has already beautifully started, I will just carry on with the introduction. Innovation in the technology ecosystem is advancing rapidly, and we have things like artificial intelligence, fintech, health tech solutions, blockchain applications, and automation tools are all reshaping industries at an unprecedented rate. However, this same speed of innovation has also increased the risk of idea theft, code copying, and even unfair competition. Because once a product goes live or a prototype is shared, it becomes vulnerable to imitation automatically if it is not legally protected. A notable example was the case between Waymo and Uber, where Anthony Lewandowski, a former Google engineer, of downloading confidential was accused of downloading confidential self-driving technology files before leaving to establish a startup that was later acquired by Uber. Interesting stuff, I know. Anyways, Waymo alleged that Uber benefited from stolen intellectual property, and the matter had to end up in a settlement where Waymo received 34% of Uber's equity, valued at $244 million. So you see, that intellectual property that you're playing around with, it can be worth so much money. Anyways, in another instance, a startup lost its core competitive advantage when its head of research left the company and used proprietary algorithms to launch a competing product. These situations are not rare. They demonstrate a growing challenge faced by tech driven companies that do not protect their intellectual property. So, this is a warning to you coming into this webinar to protect your intellectual capital. Now, why should you think about IP early? Why is that something that should be at the forefront of your mind? Ijoma, are you ready so that you can take this? You can continue, or should I continue? Okay, I guess she's not yet ready, so we'll continue. I guess you have me for longer today. Anyways, why should you, as a startup, think about IP, think about intellectual asset protection early? For startups, your IP is not a theoretical legal concept. It's a business tool. It's a tool that, if when used right, can even generate revenue for your business. So early stage founders often postpone IP planning because they are focused on building products, scaling teams, and raising funds. However, unduly delaying IP protection creates serious risks. Risks like number one, when you deal with it early, it can prevent future ownership drama. Because as your team grows, whether you have co-founders or you have developers or you have designers, interns, anyone that generally joins your team, you need to define who owns what. If you don't have IP assignments in place from day one, disputes will arise. And nothing kills momentum quite like a co founder walking away with your core technology. Imagine that. Imagine the drama that will raise. Another reason why you should think about IP early is investors will check the status of your IP and whether or not it's adequately protected. Because I don't know if you've heard, but a lot of founders, especially in Nigeria, once they have identified their intellectual property, they go about touting it, especially if their intellectual property is or happens to be a patent, or they've applied for a patent registration. They don't shut up about it. And when you have such intellectual property that you have taken adequate steps to protect, it kind of gives you pride. And you know that when investors do check for them, you would have them ready to go. Another reason why you should think about IP early is intellectual property protection, when protected right, discourages copycats, because once you've put your idea out in the public, then it's open for imitation. And if you have adequately protected that idea, when anyone comes to imitate it or to copy it, you can sue them for infringement and have the opportunity to receive damages. Another reason why you should think about IP early is because when you protect your IP, it is a business asset to you, your team, and the company generally. Another reason is fixing. When you don't deal with IP in the beginning, fixing whatever mess comes out of it later is not fun. It takes a lot more resources, takes a lot more money, takes a lot more brain power, manpower, and everything to clean up any messes that whether it's infringement or whether it's ownership dispute or whether it's how to get payment for royalties and all, it can get quite messy trying to fix it later in the day if you do not take care of it from the get-go. So these and many more are reasons why founders, especially early stage founders, should deal with IP now at the very beginning before they start to gain notable traction, or even before their team increases to a substantial level, or even before investors are added to the group or to the company, whatever the case is. More so, intellectual property also influences company valuation and investor due diligence. For most technology startups, IP is the company's most valuable asset. During fundraising or acquisitions, investors assess more than product traction. They also examine the strength of the startup's IP position because IP affects your valuation in several ways. Because IP affects your valuation in several ways. One of those ways is that when you have IP or when you have intellectual property protection, it signals credibility for you and your team. It builds a defense for you against imitations and infringement. It reduces legal risks from ownership disputes and infringement and all of that. It supports your future revenue opportunities because now, besides having a client base, or besides having figured out your product market fit, you also have this intellectual property that is prone to give you money, or that is attractive to investors, something else besides your product that is also generating revenue for you. Having IP also creates deal leverage because imagine if you've built something magnificent now, and let's say maybe you patent whatever the thing is. Having that patent alone gives you some kind of leverage in the market, especially when you're conversing with investors. Because now, not only do you have product market fit, not only has your solution gained traction, you also have this intellectual property that is a revenue generator or that is giving you a competitive edge in the market. Imagine how good and how attractive that would make you in a market full of people that don't have such a thing. But however, there is one myth that people usually have about intellectual property, and they believe that intellectual property or conversations about intellectual property or even the legal aspects of intellectual assets are only for large corporations. Let me bust your bubble. This is very, very, very false. Many startups have successfully protected their innovations early, and they have leveraged their intellectual property strategically during negotiations and funding rounds. Even a basic step such as registering your copyright or even registering your trademark over anything can give you a or can make a significant difference in your company. So no, IP is not just for large corporations, it's for anybody who has an intellectual asset. But what is the goal of this webinar? As we have already told you thus far, this webinar is intended for every startup founder to know the difference between copyrights, trademarks, patents, and trade secrets, how each of them applies to your software and the technology that you are building, whether it's a software or it's a hardware. I'm also going to tell you about the IP mistakes that silently kill startups, how to protect your startups even if you're on a very, very tight budget, essential legal documents that every founder must have before scaling, and the exact steps to take today to start protecting your innovation. Let's get started, guys. I'm excited. As we've already discussed, intellectual property is the legal protection or is a legal protection given to ideas. And those ideas can be anything from your technology, your any of your brand assets, your products, your anything literally that is an original creation can be protected under law and is protected under law. That's why we have the concept of intellectual property. For tech startups, intellectual properties can cover things like your source code or your object code. It can contain or it can cover your product architecture, your algorithms, your data models, your designs, your user interfaces, research, even the company's name, your logo, your tagline, whatever it is that kind of is a creation or an original work of the company and the founders behind the company is protectable under intellectual property. And these are often the most valuable assets that a startup owns. And IP laws exist to ensure that such assets cannot be used or commercialized by others, or even to give them undue profit without the owner's express consent. In the tech world, we all know that innovation moves really, really fast, and ideas are sometimes very easy to copy. A product that takes months to build can take a few hours to be replicated if it's not properly protected. That's why IP protection is more than a mere legal formality. It is a strategic business necessity. But enough about IP in general. Let's get down to the details because the details are what makes anything interesting. Now, how can you register your intellectual property? Well, generally, there are four main types of intellectual property. They have the copyrights, they have the trademarks, they have the patents, and they have the trade secrets, right? Now we'll break them down one after the other so that you can see which is which and which one applies to you and how you can go about registering them. Copyrights are literally, they're actually my favorite. But anyways, copyrights are the most famous and the easiest intellectual property to have and to protect. Copyrights are they are legal rights that protect the original that protect original works of authorship fixed into a tangible form of expression. In the tech world, that can include your source code, user interfaces, product documentation, mobile app layouts, website copies, icons, design assets, and even certain content structures. Copyright does not protect ideas or concepts, it protects the actual expression of those ideas. That's why it's imperative that whatever idea you have must be fixed into a tangible form of expression, whether that's a photograph or whether that's you haven't written it down, something that idea must be fixed one way or the other. As I mentioned earlier, copyright is the simplest form of intellectual property there is. It arises automatically upon creation. Isn't that nice? Immediately you think about something and you affix it into a tangible form of expression, copyright immediately protects that work and recognizes that work as belonging to you. However, registration of that work or of that thing that you did as a copyright strengthens the legal rights that you have and your ability to enforce them. A copyright registration serves as proof of ownership and allows claims for statutory damages. For founders, this means that you need to keep clear code records. Who wrote what? When was it written? In what state was it written? Was it a work for hire? Was it, things like that? You need to keep records of them. And be because when you keep clear records of them, you're able to attribute ownership and benefits appropriately. Because when a startup scales or seeks investors, being able to prove authorship of your code, especially if it's your source code, is crucial during due diligence because you do not want the drama of someone walking away with your code or investors asking you who owns what and you're unable to tell them who owns what or give them proper clarity. That just sucks. And nobody wants to be in that position. So if you have even the core of your technology can be protected under copyright in certain instances. Now let's move on to trademarks. Trademarks protect unique brand identifiers. So anything that your business is known by, anything that people can associate with your business. Just think about, let's say Nike, for instance, the mark, the mark that is ticked good, and just do it. People associate that with Nike. When you think of Adidas, the three stripes, the three usually white stripes, they are what separate, or it's what people associate Adidas with. And I bet you those three stripes are probably trademarked. You see the Coca-Cola, the way that the Coca-Cola bottle is shaped is a trademark of theirs. And I could go on and on and on and on listing popular trademarks that we probably know. So anything, literally anything that your business is or can be known by, a unique brand identifier, is protectable under trademarks. For startups, trademark prevents brand confusion, and it stops others from using similar names or visual identities that could mislead others. Imagine I wake up tomorrow and I say, you know what, I'm going to create a line of sportswear, a sportswear line, and I'm going to have 4 stripes instead of 3, and I want to register it in the same jurisdiction as Adidas is probably registered in. Obviously, they will flag that because I'm like, okay, Adidas is 3 stripes and I want to do 4 stripes. That is clearly going to cause confusion in the market. So Adidas will take appropriate steps to make sure that I do not go ahead with that registration. That is exactly what trademark does. It protects your brand and it protects your unique identifiers. Unlike copyright, which is about proof of ownership, trademarks are about identity. They're about your brand and they're about trust, public perception, public trust. They help customers distinguish your product from competitors and they prevent others from using confusingly similar names or brand identifiers to yours in your industry. Take Flutterwave, for example. The name, the logo, and even the brand slogan are all trademarked. If another fintech startup launches as Flutterwave or Flutterflow Payment, they would face serious legal backlash. Even if they are, the back end of their codes and all that, even if the back end is vastly different from Flutterwave, the fact that the name is confusingly similar will raise flags, and Flutterwave will immediately push back just to avoid any kind of market confusion. So trademark rights, unlike copyright again, trademark rights begin at the moment of registration. It doesn't matter if you've been using it for 100 years, it doesn't matter if you started using it yesterday. Trademark rights start to count when you have applied to register that trademark. And even if you might have some kind of usage rights, because again, you were the first to use, the trademark, even if you might have such rights, they are not as strong or as reliable as having legal protection through a registration. And now, once you have registered your trademark, it lets you claim national or even territorial ownership. It helps you block imposters. It helps you build brand equity that investors can trust because strong trademarks become assets on their own. Think about Coca-Cola, think about Paystack, think about Apple. These brands, with or without the product, these brands have done so well over a long period of time that the brand itself, the company itself, now has commercial value. This is what trademarks help you achieve. On to the next, which is my second favorite, also the least talked about type of intellectual property, is patents. Patents protect inventions and technical innovations. They mostly are hardware inventions that introduce new ways of doing things or affect an object's functionality, which is where you have the utility patent, or even its appearance, which is the design patent, or the biology of an object or of a thing, which is, the plant patent. Now, patents are powerful, but they are also the most expensive and the most time consuming form of intellectual property. Patents are powerful, but they are also the most expensive and the most time consuming form of intellectual property protection, whose rules vary across jurisdictions. Now, I do have to mention that for most countries or for most jurisdictions, patents are limited to hardware. You can only bring a hardware, something that is in physical form to be patented, or something a hardware is the only thing that can be patented, while in some other jurisdictions you can patent both a hardware and a software. So you just have to find out which jurisdiction you are in and what your country or your area or your jurisdiction allows. That would help you guide your registration processes. But anyways, moving on. A patent gives exclusive rights over a technical invention. It prevents others from making, using, selling, or even importing the same invention without permission. Patents do not arise automatically. They require a formal filing process that must satisfy very, very strict legal criteria, and a provisional approval must be obtained before any patent rights apply. Now, let's look at the difference. Copyrights apply automatically, right? but yes, they might need legal registration to actually be enforceable. But for the better part of it, it applies automatically. The moment you affix whatever idea you have into a tangible form of expression, it applies. Trademarks, on the other hand, they start to count once you have applied for the trademark rights. Once you have applied for it, then it starts to count. Patents, on the other hand, you must receive a provisional approval of that patent or for that patent before it starts to count. For whatever reason, you must receive that provisional approval. And patents are typically in effect for 20 years. So after 20 years, you cannot renew your patent. It now becomes commercial property. So you can then take further steps to protect whatever patent it is as a trade secret. But I leave that up to you and your team. And also, it's not all the time that you can do stuff like that, especially if whatever it is that you patented is now public knowledge. But anyways, like I said, it's on a case by case basis, so we won't really dive deep into that. Another interesting fact about patents is that an invention, if you, let's say you create and you produce or create this innovation or this invention, and you start to spill or tell the general public every single thing about it, automatically that thing is ineligible for patent protection, because once the general public knows about it, then you can't then patent it, because now it's general information, right? So if you have the thought or the idea, or you have a product, an innovation that qualifies for patent, keep your mouth shut and make your application and receive your provisional approval for your patent. Let your patent rights start to count before you start to tell people what your innovation or invention is all about. Because if you spill before you protect, you kind of lose the rights to protect. So don't do that. Interestingly, not every single thing that is an innovation or that you term an invention can be patented. To qualify, an invention must be genuinely new. It must be new, it must be non obvious to others within the industry or within that niche, and it must be useful, because you can't have something useless and patent it. That is not going to help anyone, really. You cannot patent abstract ideas or simple algorithms. Courts now insist on a demonstrable technical effect. For example, TikTok's For You page algorithm isn't patented because it is a recommendation model that could be considered abstract. Besides, they are not the first to have a recommendation model. However, Apple patented its Face ID because it used a unique combination of sensors, infrared technology, and pattern projection. Uber patented search pricing. Amazon patented one-click checkout. These patents created real competitive walls and value for the company and within their industry. However, patents, as we mentioned earlier, they take time, they take money, and they require expertise. That's why early stage founders often postpone patents, because they're like, I don't really want to think about all the time and the resources that is going to cost me, unless they have, let's say, the unique engineering advantage that a competitor might still, then they would consider it. But if you have something, please take the time now to register it. Patents make more sense when you are building infrastructure or a core technology that others may copy and commercialize faster than you. So whatever it is that you have, please patent it immediately. Okay? Moving on, the fourth brother of this group, we have trade secrets. Whew, okay, so not every invention should be patented or published or copyrighted or should even lead to a brand identity or association. Some of the most valuable assets a startup owns are best protected through secrecy rather than information, or rather than patents or copyrights or trademarks. And when you have any kind of information that gives you a competitive edge in the market, it's best you protect it as a trade secret so that it's not easily discoverable or not even discoverable at all by third parties or even by outsiders. Trade secrets can include formulas, proprietary algorithms or models, data sets, client lists, internal processes, research data, product roadmaps, pricing models, or any information that gives a business a competitive advantage. What makes trade secrets valuable is not registration but confidentiality, because once they become public knowledge, protection is lost forever. And protection depends on keeping the information confidential through internal controls such as NDAs, confidentiality clauses, access restrictions, and other security policies, even encryption, anything to help you maintain the integrity of that information. For example, now, Coca Cola's formula has remained a trade secret for over a century, protected not by patents, but by strict access control and confidentiality agreements. In the tech world, Google's search ranking algorithm and OpenAI's model training data are prime examples of modern trade secrets. They cannot be copied or reverse engineered without breaching confidentiality obligations. Startups often underestimate the importance of managing secrecy properly. Without documented NDAs, secure data handling processes, or controlled access to code repositories, a single contractor or, let's say, disgruntled employee could leak critical intellectual property. And once that happens, legal remedies are limited because you cannot take a secret back into secrecy once it has been exposed. You can't untell an information once you've already told it. So you anything that is even going to give the minutest risk of exposure is absolutely frowned upon when it comes to trade secrets. And unlike copyrights, trademarks, and patents, trade secrets last as long as that secret is kept. So if that secret is kept for a minute, it lasts, well, for a minute. If the secret is kept for generations and lifetimes upon lifetimes, well, then it continues to be a secret until for however long it is kept. Again, Coca Cola, whose formula has been a secret for generations. Trade secrets are cost effective, they are flexible, and they are very, very powerful once handled correctly, making them an essential tool for startups building core technologies, data sets, or algorithms they prefer to keep out of the public domain. Interestingly, the fundamental difference between copyright, trademarks, patents, and trade secrets become clearer when applied to a single tech product. We Let's use a perfect example. Let's craft something now. Let's say you build a smart healthcare wristband, right? Let's say you build a smart healthcare wristband called Sync Pulse, which monitors your heart rate and predicts cardiac stress using predictive analytics. The name Sync Pulse, along with its logo and other things that people can associate, maybe the color, maybe the way the name is called, maybe the shape of the wristwatch, the way it adheres onto your wrist and all that. You can protect that under trademark law because these are brand identifiers, things that help people associate that thing to your company, to your brand. Now let's go a step further. The source code upon which Sync Pulse runs and operates, as well as the UI design or even the copy, whether it's the website copy or the way that the interface on the wristwatch is all arranged, you can protect that under copyright. Can you see how we're going now? Now, let's take that a step further. Let's imagine that the shape of this wristwatch is something truly monumental and is something ingenious that no one ever could have thought of, and it's something absolutely new, or maybe it's the buckle of the wristwatch or something about the ornament, the beauty of that wristband is completely new and it's an innovation. You could protect that under patent. Now imagine that there is something about that wristwatch that gives your company a competitive edge in the market that could be protected under trade secrets. So you can see that intellectual properties are layered. It's would I say it's often rare that you see one intellectual asset would only apply to one type of thing. Let's even say you write a book. The name of the book and the content of the book can all be protected under copyright. But then let's say the name of the author has a pen name, and that pen name is truly unique and belongs to only them, they can trademark that pen name. So you see, let's say the book is shaped, there's it's a special kind of book where you open it, it starts to sing, or you open it and birds start to fly out, or you open it and as when you open the book, it starts to it recreates visually what the book is actually talking about. You can probably register that on the patent if it qualifies. So they're all layered. Intellectual properties, both trademarks, copyrights, patents, they are all layered. And so it's important, it's imperative that you figure out what your company's intellectual asset is on time and take adequate steps to protect it. Because the real danger for founders is not ignorance. It's not that they don't know that they need to protect their intellectual assets. It's often confusion. Either that they don't know under what to register their intellectual asset, or they don't know, what in their company qualifies as an intellectual asset, and on it goes. Because many people sometimes they can confuse trademarks with business name registrations, and then they'll tell you, "Oh yeah, I've registered it with CSC, so I'm covered under copyright." No, business registration and brand identifiers are not the same thing. So please take note. They are two different entities, two different things, and should not be mixed together. So, like I said, most times the issue is confusion, not ignorance. So, as a startup founder, it's your responsibility to learn about these things and to take adequate steps to protect and even educate yourself and your team. Now, what are the IP protection strategies? You say, okay, let's say now, oh, Nama, I have all my product, my thing has all the layers. It has copyright, it has trademark, it has this, it has that, and blah, 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 blah. What are the strategies to protect my asset, whether or not it belongs to one class or all classes? The first thing to do is beware of collaborations, partnerships, joint ventures, or anything really that happens before you secure your intellectual property. So I know that you're excited about your idea and you're bringing in team members and you're granting them equity and everybody's all happy and you're doing things, and this one is developing the code, the other one is adjusting the code, this other one is writing the user interface and is giving you the ad copy, and the other one is designing this, and you don't know who owns what, and you just shook hands and you smiled when they came into the team and everybody's working at their own pace. That sounds exciting until it comes time for you to figure out who actually owns what, and then or God bless you, your product starts to gain traction and it becomes this huge corporate behemoth, and it starts to make money, and then the intern that wrote your ad copy comes and is like, wait, I remember I wrote this ad copy and I didn't get compensated for it. How do you solve issues like that? So the very first strategy to protect your intellectual property is beware of collaborations, partnerships, joint ventures, or any other liaison of that sort that happens before you secure your intellectual property. Because if the idea becomes successful, ownership disputes can arise. And nobody wants that. So it's best to keep records of where ideas came from, equity stake conversations, expectations, and what happens when one exits before the idea becomes profitable. Have the tough conversations early. The second strategy you can use to protect your intellectual property is enforce cybersecurity measures to avoid data breaches and leaks that may corrupt or erase your intellectual property. You also need to understand and adhere to international IP laws, especially if your product extends beyond your country's borders or protection. The fourth protection strategy is that you need to recognize that your intellectual property is an asset, and you need to therefore treat it as such, because doing so will create an advantageous position for you and for your company during negotiations. You also need to strategize the timing of your IP registrations with an IP expert or an IP lawyer, because in most countries and for intellectual properties like patents, they become ineligible for registration if they have been publicly revealed. So you see, you need to stage the timing of your intellectual property release or of your intellectual property registration. Let me give you a Nigerian example. I don't know, y'all, if you guys heard about the Zap Africa and Zap by Paystack situation and the entire drama that went down because of that. And one of the problems was that Zap Africa it staggered the registration of their intellectual property, leaving the core IP, their core function, which was as a financial service, peer-to-peer trading with crypto and all that. They left that registration for last. And guess what? Paystack registered just before they did. Paystack got their trademark registration approval on the 24th, either 23rd or 24th. And then Zap Africa applied for theirs the next day. You don't want that to be you because unfortunately one of them will have to rebrand and you don't even want so much as want to be in that position. So it's very, very important that as a founder, take the timing is very, very important. Take the timing of your IP registrations seriously and deliberate and discuss and finalize on them with an IP expert. Another IP protection strategy is you need to be careful with open source software implementation. Open source software is a good base, yes, for new products because it is cost effective, it's an abundant resource for learning, and you can find developers very familiar with it. But it is possible to break the software's terms and conditions if you didn't read them. And in rare cases, the software's creator can change its terms and conditions from either free to paid or open to private, which can then mess up your entire infrastructure. So if you're building with anything related to open source software, you need to build with care. Another, protection strategy is if an employee contributed to your intellectual property, have them assign their rights to the company for consideration. If you are an employee creating an intellectual property, make sure you do it on your own time and without the company's resources. This ensures that you retain rights to your intellectual property. If you created IP as an individual, make sure you transfer it to the company when it is registered through a written agreement in exchange for shares. It is advantageous because the protections of a company automatically cover the IP, and it is also detrimental because the IP no longer belongs solely to you. Your ownership will now be limited to your equity stake in the company. So if you decide to, give the company rights to your intellectual property when you do build it, you need to think about it carefully because either way, there's pros and there's cons for either one. So, think about that carefully. Now that we've, broken down the four categories of intellectual properties and you understand how to protect the strategies to use to protect your intellectual property, regardless of what kind of intellectual property or what category of intellectual properties they fall under, what are the common mistakes that most founders make so that you don't make them? Okay, let's dive into that. The very first one is not conducting a detailed intellectual property search before a business model is built around that intellectual property. There's so many examples to mention that I wouldn't even go into that. When you don't conduct detailed IP search and then you go build a business model around that thing, and then once you gain traction, investors are on board, you now realize, oh wait, another company has this. I need not tell you how silly you might look doing that. So let's not do that. Okay. Another mistake is public disclosure of ideas before filing for protection. This can bring them into the public domain and prevent these ideas from being protected, especially if they are patents, worse, if they are trade secrets. Even with trade secrets, excessive disclosures can prevent or cancel the effectiveness of any protective measure. Not establishing clear IP ownership provisions in employment agreements or with third-party providers, not using IP maps and adequate database analysis to create an R&D project, which basically goes back to our first point of not conducting a detailed IP search. When you don't monitor your competitors' intellectual property, because I'm not saying go and monitor them to infringe on it or copy theirs or no. When you monitor your competitors' IP, it gives you insights into what they're doing. to which you can then strategically respond with marketing efforts or R&D activities of your own to create healthy banter in the market and also to give you an idea, a peep into what you're doing. Not identifying, protecting, or utilizing existing IP, including know how, which can become trade secrets. So, periodically ask yourself, what exactly are we doing better than others in the market? This will most likely point you in the right direction of where to start looking if you want to identify and utilize your intellectual property. Then we have the lack of IP documentation. You need to document your IP, where from the ideation stage to the whiteboarding sessions to the research you conducted to come up with that thing before concrete results are reached. Every single facet of the step that got you from idea to creation should be documented. When you don't have a budget for intellectual property protection, you keep pushing it further and further. I'm like, I'll do that next year. I'll do that in the next 6 months. I'll do that. I'll do that when we get traction. I'll do that when investors come on board. Until eventually, when you do it, you do find out that someone else has done it before you, and now you have to either rebrand or pay them to buy your brand back. Right? Either of those things suck. So do it and do it on time, please. Okay. Not protecting your IP in the right jurisdiction. I don't even need to expand on that. You can figure it out yourselves. You're smart people. So now that we've discussed the mistakes that founders make and how you can avoid making them, what are IP clauses that every founder must include in their contract? There are so many clauses, and honestly, it's dependent on the agreement you have in place with, however, whether it's an agreement between co-founders or it's an actual IP assignment or licensing agreement or it's an agreement with your vendors or agreement with your team. It generally depends on which kind of agreement you have that would then necessitate the type of clauses to include, which we'll deal with next month in our Tech and Terms webinar. But for now, I'm just going to give you guys a quick, snippet of what you need. So we have the ownership of work product, which is basically the work hire, clearly stating that this is a work you did when we contracted you to do this very thing, and so therefore it belongs to us. Then you have assignment clauses if you want to sell that IP to someone else. Then you have moral rights with, because I created something, so I own moral, or I have moral rights to it. Whether or not those moral rights are enforceable is a whole other question, which usually is always no. But I have moral rights to that thing, and so therefore, if I'm as the owner of that copyright, I would not want a third party to have moral rights to that creation. Then we have confidentiality and trade secret clauses. We have IP indemnity clauses, and we have non-compete and non-solicitation clauses. So these are all important clauses that you need in any given agreement that you have. I'm blessed that you have with any third party. Now, let's go into my favorite aspect of this topic. And I'm sure it's your favorite aspect of it too, because we're talking money now. How to monetize your intellectual property. How? How can you actually make money from these intellectual assets that you have been working on for a pretty long time? The first thing is you can either license the intellectual property. Licensing is literally the most common way to generate revenue from your intellectual property because it involves granting another party permission to use your intellectual property in exchange for a fee or royalties. There are several types of licensing agreements. There are exclusive licenses where you grant one party the sole right to use your intellectual property within a specific market or region. We have the non-exclusive licenses where you allow multiple parties to use the intellectual property simultaneously, which is my personal favorite, but let's not talk about that. We also have sub-licensing where you enable the licensee to further license your intellectual property to third parties. So imagine there's a chain and you're at the very top of that pyramid or that food chain, and then you license it out to the first tier of direct customers, and then those direct customers sub-license it to others, and then the others and then you just keep having this chain of income and on and on it goes. So yeah, fun stuff. Anyways, Licensing works for different intellectual property categories differently. Let's say copyright licensing now. It allows other people to use your creative works while earning licensing fees or royalties. Example, musicians licensing their songs from commercials or even from movies. You hear of sync licensing. Exactly, this is what we're talking about. Or even authors licensing their book rights for movie adaptations. There are so many in the market to count up. The entire MCU is built off of a book. Well, not a book, a comic book. A comic book. And so, there's just way too many examples to count. So, fun stuff. Anyways, trademark licensing, where you let businesses use your brand name or your logo while receiving a percentage of their revenue. Example, franchises, merchandise, branding. Let's take for instance now, KFC has so many locations in so many different states and countries and all that, and I'm pretty sure it's not one management system that owns each and every single branch. There's something called franchises. They have the business model and they franchise it to others. Another perfect example is Marriott Hotels. Marriott Hotels, or even Boulevard, they don't own every single hotel branch in every single country, in every single state. Nuh-uh. They're not going to manage all that. So they franchise their business model. They give others the permission to create businesses that match the Marriott or the KFC brand value, business model, and basically things that are in alignment with it, and they give you the go ahead to use their name and their brand and their market to start up your own business and generate your own revenue. So you see, trademark licensing, beautiful thing. Another thing that we have, or another category, is patent licensing, that you allow companies to produce and sell your patented innovation for a royalty. Of course, there are no trade secrets licensing, because again, once a secret is out, it's out. So, anyways, okay. So, key considerations when licensing your intellectual property. First of all, you need to clearly define your rights and your limitations in the agreement. Establish payment terms. Are you going to be paid a fee, a one-off fee, or paid in installments? Are you going to be paid a lump sum? Are you going to be paid royalties? Is there going to be a hybrid payment? Is there something else that you're getting out of the deal? Have your payment terms be established. Include termination clauses unless you want your agreement to continue into infinity and infinitum. So, but I don't think anybody wants that. But anyways, have termination clauses and dispute resolution mechanisms as well. Ensure compliance with the law. Whether you're in Nigeria and Nigerian laws apply to you, or you're abroad and laws in whatever country or state you are in abroad applies to you. Make sure that whatever you do, you adhere to the laws. The next method, or the next way to monetize your intellectual property, is to sell or assign your intellectual property rights. If you prefer a one-time payment over long-term royalties, you can sell your IP rights outrightly. Selling IP is ideal when you no longer want to manage it or you need immediate capital. Personally, I would say don't sell. You can make more money from it in the long term. But again, it's on a case by case basis. So whatever works for you. Anyways, types of IP sales. They have patent assignments where it's like a full transfer of ownership rights to another entity. You have copyright assignments where you sell your rights to books, to your films, or to softwares. You have trademark sales where a business is acquiring a trademark for branding purposes. You have trade secret sale where you want to sell proprietary formulas or business processes. Imagine Coca-Cola decides to wake up one day and say, you know what, we want to sell Coca-Cola formula. That alone can cost billions. You see? Very important stuff. When selling your intellectual property, you need to determine the market value of your intellectual property. Don't just go at it due to desperation. Oh, I need this money ASAP. So, no. Determine what the market value is. Draft a legally binding contract outlining transfer details. Include warranties and indemnification clauses to protect against future disputes. Ensure compliance with relevant tax regulations on IP transactions. Moving on, guys. The third way to monetize your intellectual property is to franchise your business or the business model, which is kind of what we're talking about earlier in licensing. Franchising is a very powerful way to scale your business because you license your entire business model, including trademarks, operational methods, and branding. Franchise works where the franchisor, who is like the original business owner, who then licenses out the business model and the brand, and then the franchisee, who is like the individual or the company, that pays for the right to operate under the franchisor's brand. Elements of a franchise agreement in the several IP categories is, for instance, when you have a trademark license, this allows the franchisees to use the business's brand name and their logo to do whatever they want. Operational guidelines provide standardized methods for running the franchise. Then we also have royalty payments where franchisees pay a percentage of their earnings to the franchisor. We also have marketing and support where the franchisors often provide training, advertising, and business support. So when you're franchising your business or your business model that you build, ensure that you have a strong brand recognition and operational success before franchising. Just because it sounds nice doesn't mean it might work for you. So make sure that you have strong brand recognition and operational success before franchising. Develop a franchise disclosure document detailing rights and obligations. Establish a consistent quality control process to maintain your brand reputation across board. Register your trademark, obviously, and protect your brand identity. Comply with Nigerian or international franchise laws and the mode for the agreement and all. The fourth way to make money, no, the first three, but the licensing, assignment, and franchising, they're the most popular. Then we have the not so popular ways of monetizing your intellectual property, and one of them is creating digital products or membership platforms, basically communities, which is what everybody's doing now. So you can have an online course, you can have ebooks, you have subscription-based platforms, anything really that can generate revenue for you through a digital product or a membership platform. You can enforce your IP rights. I know, radical, right? When someone infringes on intellectual property, it can be payday for you because now you're like, oh, okay, you want to infringe on us, therefore you can pay us. So you can, get damages for literally for whatever damage that you have received, and then you get them to pay you a compensation. Now, we also have leveraging intellectual property for investment and business valuation. Many startups use their IP as a bargaining tool when seeking funding because investors are more likely to fund businesses with protected and monetizable intellectual property than those without. For example, a fintech startup with a patented blockchain technology can attract investors by showcasing its unique IP portfolio as opposed to someone or some company who does not have. So, guys, as you can very, very, very clearly see, intellectual property is not a luxury reserved for big companies. It is a survival strategy for every tech startup navigating today's highly competitive digital economy. Innovation alone is not enough. The real power lies in how well you have been able to protect that innovation that you have come up with. Because without a clear IP strategy, even the most brilliant product can be cloned, your brand can be hijacked, your source code can be misused, and your company can lose investor confidence before it scales. And so you find that founders who take IP seriously are not just protecting themselves, they are building leverage because protected IP attracts investors, it strengthens partnerships, it increases company valuation, and creates a defensible market advantage. On the other hand, founders who ignore IP pay a very, very high price because they can lose the ownership of their IP. There's co-founder disputes, there's lawsuits, there's product bans, and all sorts of nonsense, really, that comes, risks of not protecting early. So the path forward is very, very clear. Why it's clear to me, I do hope it's clear to you as well. It's clear that even though you're building fast, you also have to be smart about it and you have to protect your intellectual property. Put IP structures in place from day one. These IP protection strategies, put them in place from day one. Use copyrights to secure your code, trademarks to grow your brand, patents and trade secrets to protect your innovation, and software licensing to control usage. Seal ownership with strong documents because your startup's greatest asset is not your app or your website or your pitch deck or even your revenue. It's in the intellectual value that allows people to identify with you, to want to purchase from you and generally give you their money. That intellectual value powers your company and everything to do with it. The founders who dominate the next decade are not merely innovators, they are innovators who understand the law. Now is the time to protect what you have built and what you are currently building. Thank you very, very much, guys. Over to you, Jama.
Okay, thank you very much, Barista Noma, for this impactful session. I mean, I've learned a whole lot. So we have a few questions here, and I guess I'll just take them all at once. The first question we have here is, how can small businesses protect their intellectual property on a on a budget? Then the second question is, what is the role of an IP lawyer in protecting tech innovations? And the last question is, how does international IP protection work?
Whew, okay, smart questions. The first one, you said, how can small businesses protect their intellectual property on a budget? Well, you
Yes.
have to prioritize key assets. You need to prioritize key assets and use free or low cost resources for IP searches and focusing on preventative measures like NDAs or copyright notices or even agreements that lend you, or not, well, not lend, but that give you ownership or that guarantee your ownership of that intellectual property, especially if you're working with especially if you're working with third parties. But generally, I would first advise that you try and protect your intellectual property, because in Nigeria, protection of intellectual properties, except maybe patents, are not that expensive, right? So I think it's something that you can have, or create a budget to invest in. I think it's worth it. It's worth it. The second question: what is the role of an IP lawyer in protecting tech innovations? An IP lawyer, like us, it helps you navigate the complex landscape of IP law. It assists in fulfilling, we assist in filing applications, enforcing your IP rights, telling you which intellectual property category to register your asset under, um, providing strategic advice on even how to leverage and monetize that intellectual asset, especially when you're expanding to new jurisdictions or to new territories or even a whole new base of clients or customers. So yeah, that's our role as IP lawyers and what we can do to aid tech innovations. The third question is, how does international IP protection work? Well, international IP protection generally involves filing for intellectual property rights in each country where protection is needed, which is basically in each country where you have customers, clients, or users in. And you register in these countries often through treaties like the Patent Cooperation Treaty for patents or the Madrid Protocol for trademarks, and so many more treaties and legal requirements such as those. So yeah, I do hope this answers the questions sufficiently.
Okay, thank you very much once again, Barista Noma, and I apologize for my breaking transmission earlier on. Thank you so much. Thank you so much for breaking this down in such a clear and practical way. I mean, I've learned a whole lot today on my own part. And thank you to everyone who joined in. I'm certain that this has been an engaging and eye opening session for you as well. Also, we've put together some exclusive resources to help you take today's lessons even further. So we have the webinar replay link, which would enable you to watch the session again at your own pace or share it with your co-founders and your team. We also have our founders newsletter. It's a growing community which you can join. It's like a private founders circle where we share legal strategies, startup insights, and regulatory updates tailored for tech and business founders. So we would love to hear from you as well. We'd love to hear what your biggest takeaway from today's session was. We would appreciate it if you can share it in the chat or post it on LinkedIn using the hashtag Smart Start Smart and Ajin Legal. Also, this is part of our H2 2025 series, and we'll be back next month. We will be back next month with another practical session to help you build smarter, safer, and stronger businesses. And on behalf of myself, Barista Norma, and the entire Adune Legal team, thank you once again for being a part of today's webinar. And until next time, build smart, protect your ideas, and start strong. Thank you so much.
Thank you guys. Bye.